Another attorney thinks he knows what he's talking about when it comes to the Bill of Rights and the U.S. Constitution. Let's see if he actually does. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today's lecture, ladies and gentlemen, we'll be doing a quick analysis over a recent post, or relatively recent post, made by an individual going around the internet as the Internet Esquire, also known as Jake the Lawyer. Now, Jake the Lawyer, his actual name is Mr. Jake Peter Watson, and he graduated from the Southwestern University School of Law, which is another one of these ABA, American Bar Association, the self-proclaimed criminal Marxist advocate organization, one of their accredited law schools. Recently, Jake the Lawyer, well, I'll say relatively recently, posted a video on YouTube going through each of the articles in the Bill of Rights to the U.S. Constitution and explaining what he believed, what he was taught from the ABA, the Bill of Rights and the U.S. Constitution actually means. So we're going to go over that lecture, or over that presentation, and see just how accurate, if at all accurate, the assessment, the ideas that he was taught by the American Bar Association were true, and whether or not we can actually apply them. So, Jake the Lawyer, please take it away.
Okay, here's the deal. It's every American's responsibility to understand the Bill of Rights because how this country runs itself is a direct result of what we allow. What's surprising to me is that in researching this video, I couldn't find just one good definitive video on the Bill of Rights on YouTube. So let's fix that.
We do have a series on all of the amendments, including Articles 1 through 10 of the Bill of Rights in the U.S. Constitution, available on Rumble. If y'all would like me to begin migrating those over to YouTube, just let me know down in the comments and I'll get us started on doing that migration. But continue.
I'm Jake the Lawyer, and welcome back to Internet Esquire. Now, before I begin, if you'd like a deep dive into the fascinating 800-year history of how we came to get our Bill of Rights, you can click the link in the description below. I did a full half-hour breakdown on that video, which was just supposed to be the intro to this video.
And likewise, if y'all would like me to go and analyze that video, let me know down in the comments. I would be more than happy to go over this individual's content. Continue.
But, it ended up being 2 videos, and here we are. Okay, with that context aside, here's how this whole thing works. You have the Constitution and you have the Bill of Rights. Slap them together. The Constitution is the framework for government power. It is the template upon which we build the actual system of federal government. And the Bill of Rights is the first 10 amendments of that Constitution.
What I can appreciate at the forefront is while he calls them amendments, they are correctly labeled, as you can see here in the video, Articles 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And the reason for that, as overtly declared by the founding generation, is the Bill of Rights was not an amendment, a change after the U.S. Constitution was adopted. They were prerequisites before any of the individuals like Thomas Jefferson would even consider ratifying or supporting the U.S. Constitution. No, they were not amendments. 1 through 10, Articles 1 through 10 in the Bill of Rights were not amendments to the U.S. Constitution. They were prerequisites. In fact, there was an individual at the Philadelphia Convention, named George Mason, who said even after the Bill of Rights was going to be included, that he still refused to support and ratify the U.S. Constitution because it created a government. It was trying to overthrow the current government that was already working efficiently, already working effectively, that, of course, he was willing to make concessions. But the U.S. Constitution on its face, especially without the Bill of Rights, was a tyrannical government. He said even after the Bill of Rights was going to be included as a prerequisite, not as a change after the fact, he still saw too many tyrannical powers to be exercised by this new government. So I can appreciate Mr. Jake the Lawyer showing the accurate titles here in this picture, but giving a misnomer to Articles 1 through 10 in the Bill of Rights of the U.S. Constitution. Continue.
Constitution, which serve as a constitutional safeguard to protect individual liberties and natural rights. Said another way, the Constitution is the mechanism for how the federal government works, and the Bill of Rights is the safeguard protecting individual liberties as it goes to work. Now, of course, through the 14th Amendment, the Bill of Rights has been modernly interpreted as applying to the states, but let's just leave the 14th Amendment comments out of this video, please.
I would rather not. The 14th Amendment was not ratified pursuant to Article 5. And this isn't just a random conjecture. We actually addressed this in the Supremacy Clause and 14th Amendment, or addressing the Supremacy Clause and 14th Amendment lecture. The Solicitor General in 1913, in his memorandum regarding the consideration of the 16th Amendment, said overtly that the 14th Amendment was not ratified in pursuant to Article 5 because the state legislatures returned copies of that amendment, the amendment proposal, with wording errors, misspelling, punctuation errors. Well, Caleb, those are just minor mistakes. Nowhere in Article 5 of the U.S. Constitution does it say minor mistakes can be neglected or can be permitted to count as adopting the amendment. The states were able to do perfectly fine when adopting Amendment 11. They could do it for 12, 13, 14, 15, all the way through 27. No, the 14th Amendment, de facto and de jure, no matter how many times the courts want to pretend otherwise, was not ratified constitutionally and is thus not binding, is thus not constitutional.
I can hear them being typed already. Oh, now there's even more because I brought it up. Look, that's a mind-boggling history that I'm going to save for an entirely different video, so let's just put that over there for now.
It's not a mind-boggling history. It's very simple fact. Now, if you want to do the mental gymnastics necessary to try to suppose that the 14th Amendment was ratified, then that's where it gets complicated. But de facto, de jure, even prima facie, just on its face, as a matter of fact, a matter of law, on its face, the 14th Amendment was never ratified, and to this day has not been ratified in pursuance to Article 5 of the U.S. Constitution.
Now, all right, moving on. Together, the Constitution and the Bill of Rights create a governmental power structure that is limited by default. The Constitution is a system of negative powers, restricting federal government authority to only the powers that are enumerated in the text of the Constitution. And the Bill of Rights is a set of negative rights, which restrict government interference from restricting your God-given rights. This is the opposite of what we would say positive rights are, because the Constitution and the Bill of Rights is not saying that the government must allow freedom of speech. It is saying that freedom of speech exists and you, government, cannot touch it. So if you take anything away from this video at all, just one thing, let it be this. The Bill of Rights does not grant you liberty. Your liberties already belong to you. Therefore, the job of the Bill of Rights is to simply state, for the record, the things that are the most sacred individual liberties that the government cannot touch. Now, of course, there are useful exceptions to individual liberties, so try not to go absolute full Florida man all the time.
Hey man, y'all got beer still? Y'all got beer still?
Might get you in trouble. Here is what the Bill of Rights says, the actual language of all 10 amendments in simple terms, explained by a lawyer. Let's go. The First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. English, please. I mean modern English. There are 5 rights in the First Amendment. Did you catch them all? Religion, speech, press, assembly, and petition. Now what do those mean? Religion. The first 2 clauses of the First Amendment are known as the Establishment Clause and the Free Exercise Clause. The Establishment Clause means that the government cannot create an official state church or a state religion of any kind. And the Free Exercise Clause means...
Do wish he would specify here. That means the federal government, the U.S. government, cannot establish or formally create a government-supported, government-backed institution. The U.S. Constitution, like he somewhat said earlier, limits the powers of the U.S. government, not the state governments. There is only one part of the entire U.S. Constitution which directly limits or in any way interferes with the powers of the state governments, and that's Article 1, Section 9 or 10, where it lists a very small list of powers which the states are, for the benefit of the other states, for the benefit of the U.S. relationship, the League of Friendship, would no longer be practicing at the state level. No, it doesn't prohibit all governments like the state governments. It only prohibits the U.S. government.
That the government cannot tell you to attend a church or a religion of any kind, and you have the choice to practice your religion as you see fit. Together, these are known as the freedom of religion, not the freedom from religion, the freedom of religious choice. Unfortunately, freedom of religion today is often misunderstood as the separation of church and state. They are not the same thing, though they are very closely tied to one another. The separation of church and state is merely the mechanism by which we ensure religious freedom in this country, but it itself is not a right. People often confuse the separation of church and state as being a right in the First Amendment, but in fact, this is simply the legal doctrine that protects religious freedom, meaning that just because there is a separation of church and state does not mean there is a banishment of all forms of God in public life. Again, it means freedom of religion, not freedom from religion. Of course, there are exceptions to the freedom of religion. For example, if your sincerely held religious beliefs mean that you are also going to be a reckless endangerment to public health or an intentional endangerment to others, obviously there's going to be restrictions on what you're doing over there as you're practicing whatever the heck it is you're doing over there. Now, an interesting point. It's not by coincidence that the freedom of religion is the very...
And a quick way to remember this is the problem that comes up with the freedom of religion clauses and their equivalents in the state constitutions is what defines a religion. A very quick principle, a litmus test to answer that question is, does the practice of that religion infringe upon other people's rights? So say you have a religion that demands to please their God, they have to go and murder, rape, and pillage. Facilitating the practice of that religion would thereby impede upon the government's promise to other citizens to apply equal protections under the law, which means you have one of two scenarios to choose from. You can either say the religion of murder is protected, which means they can then go and murder. So then the government has to apply the equality under the law principle and allow that person who is supposedly going to be murdered to also go and murder for their religion. Or you choose the second option, which says actually, no, that can't be a true religion because it requires the impediment of others' rights. A quick summation of that idea is your rights end where the rights of another begins. You do not get to steal because that infringes upon someone else's right to the pursuit of property. You do not get to murder because that impedes on someone else's right to the right to life. And you do not get to enslave or rape because that impedes upon another's right to liberty. That's how we quickly answer that concern. That's how we answer that religion question. What is a religion?
Very first thing in the very First Amendment. This is one of the hallmarks of a free society, freedom of thought. And freedom of thought necessarily requires freedom of speech. Be careful of your thoughts. They lead to your words. That is why you must be mindful of them. Yes, thank you, Confucius. The next rights listed in the First Amendment are the freedom of speech and the freedom of the press. We cannot find the best ideas and the best ways forward if we cannot talk with our government openly. And that means even if somebody's ideas are hateful or racist or ignorant or just downright rude, disrespectful, and dumb. The government has no authority to create laws which just restrict that type of speech. Now, time and again, people get confused about the freedom of speech. Oftentimes, most pertinent example, they say something hurtful, toxic, or hateful online, and then their private employer fires them for the thing that they said. And they stand up and they go,
"But that's my freedom of speech. You can't tell me not to say that."
True, fair enough, but that doesn't mean when you work for this guy who's a private citizen or there's a private company over here that is just doing whatever it is they do. It just means that the government can't pass laws arbitrarily restricting free speech.
And there's a Latin legal maxim that goes over this. We went over it probably 6 or 7 months ago now. But it's called voluntas non fit injurium. If you volunteer, such as being employed for a certain employer, if you volunteer, whatever contract you sign, whatever terms you agree to obey, if you go and violate those terms, you don't have a claim to injury. If you volunteer for it, there is no claim for injury. Just like what Jake's talking about here, if you go and work for somebody, you say something bad online, and then you get fired because you voluntarily chose to work for that person ultimately gets to determine the terms of your employment. So if you go and violate those terms, if you go and violate decorum by exercising your freedom of speech, excellent. Your freedom of speech was not impaired. So too cannot the right of contractual obligation be impaired if we tried to deny that employer the right to, however you want to call it, fire you, kick you out from the business, so on, so forth. So he's right there. That's not a freedom of speech violation. That is, you broke the terms of the contract for working for that person. Get out.
You know that forms of dress and flashing your headlights at the next driver down the road to warn them about a speed trap up ahead are also considered forms of free speech? Yes, you can't be arrested or prevented from doing those things, but like I said before, there are limitations. Indecent exposure in public is not a form of free speech in what you choose to wear. Don't try it.
We're going streaky! Yes!
Causing roadway hazards to inform other drivers that there are police up ahead is also not a protected form of free speech. Anything that would be likely to impose an immediate threat to public safety, like reckless endangerment, vandalism, or inciting violence, is not going to be a protected form of free speech. And by inciting violence, I don't mean this. I mean more like this. Actual physical violence and property destruction is not a protected form of free speech. Hand in hand, alongside freedom of speech, we also have freedom of the press, allowing mass communication of ideas.
And it may sound absurd, it may sound silly, it may sound extreme, but everything he just said there about incitement, about public nudity, all of that, well, contemporarily seems to make sense, is not provided for in Article 1 to the Bill of Rights of the U.S. Constitution. If you don't like that someone is nude in the public, go away from that area. What if that nude person was to say your outfit was offensive to them? That's the legal consistency that we have to apply whenever we're upholding or trying to apply the principles of this free government formed by the U.S. Constitution. Well, Caleb, that's absurd. What about my kids? Don't take your kids to that area. Take them away from that area. What about inciting violence? The entire American Revolution, without the ability to incite violence, to incite resistance, would not have happened. The entire idea that there is any sort of limitation on speech is absurd. When we consider the foundational principles, the founding generation, and when we consider Article 1 to the Bill of Rights in the U.S. Constitution on its face, does it provide exceptions? Not at all. Does it provide limitations? Not at all. So all of these limitations and exceptions that have been conjured up are purely legislations and arbitrary powers that have been formulated by kings on the bench, by people in government who believe they have more power than they've been granted and enumerated. If you don't like that, then you need to amend Article 1 to the Bill of Rights in the U.S. Constitution. The principle that best applies in order to maintain a free government, no matter how unpopular or absurd or extreme it may sound, is to always prefer dangerous liberty than comfortable safety or slavery. Because if you prefer the latter, you will get neither and deserve neither.
The main limitations on freedom of speech are things like libel, which is a form of written defamation where you knowingly print false information about a person.
Nowhere is this exception provided for in Article 1 to the Bill of Rights of the U.S. Constitution. Caleb, that's extreme. Caleb, that's absurd. Then amend Article 1 to the Bill of Rights in the U.S. Constitution. Don't start getting magical and mystical, saying all of these implied powers exist where they don't and aren't verbatim stated. You can either have a government of laws where you obey the terms of the contract, or you can have a government of men where absurdity and contemporary concerns play into how the terms are going to be interpreted, defined, and applied. Choose one. If you choose the latter, you failed the founding generation. If you choose the former, excellent job. You're going to be considered crazy. You're going to be considered unpopular. You're probably not going to be liked, but you're obeying the principles of inclusio unius est exclusio alterius, applying the terms of the contract rather than what you think the contract should say.
person and it causes them direct harm to their reputation. Obscenity, language that is clearly offensive, typically of a sexual nature, and against contemporary community norms and standards. Or incitement, public speech that is likely to cause imminent lawlessness. These are all going to be generally restricted. And also remember, freedom of the press does not give the press the right to break other laws in the pursuit of a story. They cannot commit trespass or burglary or break privacy laws because they're doing it for the story.
Now that's applicable, but it's in no way related to Article 1 of the Bill of Rights in the U.S. Constitution. This is provided for in that original principle that we were discussing just a minute ago. Your rights end where the rights of another begins. There is no exception that, at least by the appearance, by the portrayal that Jake is presenting here, there is no exception or limitation providing this limit in Article 1. This limit is provided because of the other rights. Like he was saying, the right not to have your property trespassed upon. None of that has to do with Article 1 to the Bill of Rights of the U.S. Constitution.
The freedom of assembly and the right to petition the government for the redress of grievances are the final rights listed in the First Amendment, and they are specifically there to protect public action. The freedom of assembly says that people can gather together peaceably in a public place without being prohibited from doing so by the government. Most commonly, we think of this as protests, but it has also been interpreted more generally as the freedom of assembly, which means that the government cannot tell people things like who they can be friends with, who they can get married to, and what business partners they can choose. And the right of petition simply says that the government cannot punish you for going to them with a problem. Now, of course, just like the other rights, there are many exceptions to the freedom of assembly and the right of petition. Things like time, place, and manner restrictions may be placed on the freedom of assembly. For example, this would be things like requiring a permit for a large protest, demonstration, or parade that requires that that thing be done in a...
Where is that exception provided for in Article 1? Nowhere. It was something conjured up by the courts, something conjured up by legislating from the bench, something conjured up by one of the people, or many people probably, in governing positions, which believed they could exercise arbitrary powers that they weren't granted. If this exception is true, show me where it exists in Article 1 to the Bill of Rights of the U.S. Constitution. You can't, because it doesn't exist.
Particular time, place, and manner. Noise ordinances, limitations on solicitation, and restrictions on blocking public thoroughfares are all going to be reasonable restrictions on the freedom of assembly and the right of petition. Illegally taking over an interstate and starting a riot when somebody gets hit by a car accidentally is not going to be a form of protected free speech and assembly. So that's the First Amendment. It protects some of the most important natural rights and individual liberties on how we think, speak, and act.
The First Amendment is first for a reason. The Second Amendment is just in case the first one doesn't work out.
That's a brilliant interpretation, actually. The Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I still fail to understand what's complicated about this. I think it's contextual. Well, maybe it's just people just want to ban guns entirely. But in case it's contextual, allow me to give you some context. The Second Amendment is a sort of mixture of language taken from other state constitutions at the time, which all largely say the same thing. Pennsylvania, in their state constitution, said it like this, that the people have a right to bear arms for the defense of themselves and the state. Massachusetts said it like this, the people have a right to keep and bear arms for the common defense. Virginia said it like this, that a well-regulated militia, composed of the body of the people, trained to arms, is the proper, natural, and safe defense of a free state. The main concern of why this amendment exists is fear of a standing army in peacetime, as it might become troublesome to a free state. You know.
Precisely, which is why you should go watch Federalist Paper number 45 or 46, where James Madison, father of the U.S. Constitution, said, even if the U.S. government were to try to gather up a standing army, which he directly denounced, so things like the U.S. Army, U.S. Marine Corps, U.S. Air Force, U.S. National Guard, DHS, all of that is completely illegitimate in the eyes of the father of the U.S. Constitution. He said even if the U.S. government were to go and do that, it would be outnumbered 1 to 25 by the citizens and 1 to 10 by the able-bodied citizens. He was calling on the citizens. He was anointing the citizens with a duty. They are duty-bound to physically and diplomatically resist and displace any standing armies that were to be gathered up and imposed, organized by the U.S. government.
Tyrannical. Therefore, the people should be personally armed to provide for their own defense. We know that this was the concern at the time because places like Virginia said this: standing armies in time of peace should be avoided as dangerous to liberty, and that in all cases the military should be under strict subordination to and governed by the civil power. The militia is not the military. It never was, it never has been, and it never will be. The militia is the people, the body of free citizens.
But it says well-regulated militia. Even if it is the body of the people, that means well-regulated.
Look, anybody who conflates this with the military and thereby government oversight is just flatly wrong. Well-regulated doesn't mean well-regulated by the government. It means a well-ordered people. This is the well-ordered militia. The idea of ordered freedom is the ideal thing that the entire Constitution and the Bill of Rights is going for. Now you might say, fine.
The right to bear arms only applies in the context of a militia. It is not a personal right to own a firearm.
I hate to break it to you, but it is exactly that. You can't have a body of citizens who are not the government be armed as a necessity to the security of a free state without having them be personally armed. The militia, as in the people, is the mechanism by which the security of the free state is ensured. If anyone or anything becomes a threat to that security, whether that's an individual or a foreign or a domestic standing army, the Second Amendment is there to ensure its defense.
Okay, but today is different because today we have a military that's peaceful and on our side and here to defend us. So why do we need a militia?
This is an honest question. You honestly think that this country would be better off if the only people that had firearms was the government? You lived through 2020 and you feel that way? Is that... Yes. The Second Amendment means that the people, and therefore the militia, can be turned against the existing government if that government becomes destructive of the purpose for which it was designed. Is that a good thing? No. That would be absolutely horrible. But let's be clear. The Second Amendment is not a hunting right, okay? It's not a right to protect people who are into shooting sports. It is the right of revolution manifest. Does that sound extreme? Yes, it does. It was written by extreme men living through an extreme time who fought off the mighty British Empire to create a country and a nation that had never existed before on the face of the planet. And the first document that that nation ever wrote was the Declaration of Independence, which states this: that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundations on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. This is reinforced by several state constitutions that also specifically and expressly state a right of revolution in their constitution. I'll give you an example. New Hampshire. The people have a right to reform their government and have a right to resist and even to overthrow government when the protection, security, and happiness of the people are endangered. Virginia, Vermont, Pennsylvania, and other states also had similar explicitly stated rights of revolution right there in their state constitutions. Now, with that context, look at the Second Amendment language and tell me that it is not exactly what I just said it is.
Gun.
Gentlemen, we cannot just have an amendment that says guns. What about guns?
Having them.
Moving on. The Third Amendment, America's sleepy little angel. No soldier shall, in time of peace, be quartered in any house, without the consent of the owner, nor in time...
I do want to make sure, just very quickly here, the reason the founding generation didn't use the word guns or even firearms, rather use the word arms with a capital A, as we explained this in the Defining Arms lecture, was because the entire point of having, as Jake fairly reasonably explained there, The entire point of the citizens being armed was so that they could deter any sort of tyranny that would be leveraged by their government. So if you trust the government with a monopoly on any type of arm, you're contradicting that very principle, which means the word arm, as we showed very clearly in the Defining Arms lecture, does not include just firearms, does not include just guns, rifles. It includes anything and everything. It includes all tools used for an offense, which was definition in Samuel Johnson's 1755 dictionary, the dictionary which the founding generation almost certainly used whenever they were drafting the U.S. Constitution. So no, the second article to the Bill of Rights in the U.S. Constitution is not about guns, it's not about firearms, it is about any type of weapon of offense. That's the definition in Samuel Johnson's dictionary. If y'all haven't gone and watched that lecture, I highly encourage you to do so. We provided quite a few receipts, quite a few bits of information that supported this idea and showed very clearly as to why the founding generation used arms and not any sort of time-specific technology in Article 2 to the Bill of Rights of the U.S. Constitution.
Time of war, but in a manner to be prescribed by law. Now, a lot of people make fun of this amendment, as I just did, because it's never become an issue. We've never had to deal with the problem, but I can guarantee you, if the Second Amendment was ever truly needed, the Third Amendment would very quickly become a problem. And that's exactly why it's the third. Thank God it has never been an issue. In layman's terms, it says that the government cannot force you to keep soldiers in your home during a time of peace. This was very much a problem during the time of the Revolution and before, where the British Crown would send redcoats out and force people to house them and to feed them. But it also says that the government can do this in a time of war if done in a manner prescribed by law. That's where things would become really ugly. And let's just hope that this sleepy little angel boy stays exactly the way that he's always been since he was born in 1791. The next amendments, the 4th, 5th, 6th, and 8th, lay out the general body of rights known as the rights of the accused. And the reason why these amendments come directly after the 1st, 2nd, and 3rd is, again, not by accident. 4th Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Okay, the 4th Amendment protects you from unreasonable searches and seizures by the government. This includes them taking or searching you, your personal property, your private information, or your home without good reason. The taking and searching cannot be unreasonable. Okay, unreasonable. What does that mean? Reasonable generally means probable cause, which means the facts and circumstances, if presented to a reasonable person, would likely have them believe that the information is sufficient to say, a crime or evidence of a crime, it's probably going to be found here if you dig into it. In most cases, a warrant must be issued before a search and seizure, and also the 4th Amendment specifically requires that warrants shall not issue but upon approval from, say, a judge or a...
That's not true. It says no warrants shall issue but upon probable cause, supported by oath or affirmation. There is such a thing as citizen-issued warrants. I mean, our 911 calls aren't exactly to the level of warrant. They are more the basis of probable cause. But no, issuing warrants is not exclusively a judge-provided power. And if you notice, in Article 4, nowhere does it give that right exclusively, or that power, rather, exclusively to any singular magistrate. It says no warrants shall issue, but upon probable cause. Does it say a judge only can provide probable cause? Does it say a police officer can only provide probable cause? Does it say an executive, a legislator? So, no. It says but upon probable cause, supported by oath or affirmation. And that second part is to deter people from making false claims, from wasting time, and, far worse, from infringing upon anybody's pursuit of property, exercise of life, or liberty. If you swear under oath, and it turns out that there was no probable cause, and the warrant was based on false premises, or issued on false premises, if you swore under oath, that is perjury. Perjury is also treachery, breaking a promise. Promise to what? Tell the whole truth. Both of those are criminal offenses. No, this power is not exclusively for judges to exercise.
Sworn magistrate. It also requires that warrants must be specific. They must state exactly what is going to be searched and specifically detail what is going to be seized. In simple terms, your person, your property, or your privacy are all highly protected rights that if the government is going to take them away from you, it needs to follow very specific rules. And like all of the amendments, there are, of course, some exceptions. If you voluntarily consent to a search, even if you didn't know you had a choice, there is no warrant requirement. Searches that result from lawful arrest are also an exception. Police do not need a warrant to search your person or the area under their immediate control if they are already lawfully arresting you. Plain view is an exception. If police are lawfully present in an area and can plainly see evidence of a crime or the commission of a crime, there is no need for a warrant. Cars can also be searched or seized without a warrant if police have probable cause that there might be evidence inside of them. There is also the stop and frisk exception, known as the Terry stop, in the famous case of Terry versus Ohio. Terry, why are you suing Ohio again?
Man, they keep stopping and frisking me on the street. I don't know what's going on with these guys. I don't know if these cops were in the Navy before they did their duty or what, but they keep frisking me.
No, a Terry stop is really simple. The basic concept is this. If you're acting suspicious on the street, then the police can establish what's known as a reasonable suspicion. A reasonable
No, they cannot.
person would look at the person on the street and go, that person is acting suspicious. That allows the police to temporarily detain you, ask you some questions, and search your person immediately for weapons to establish whether or not you're a danger. But don't be
None of that is provided for in Article 4 to the to the Bill of Rights in the U.S. Constitution, and in the vast majority of the state constitutions as well. None of this is based in constitutional law or foundational principle. A quick way to know that for absolute certain is they actually didn't have police departments or anything like that. The vast majority of the states, if not all of them, didn't have any sort of police department that would be conducting these duties. No, what Jake is saying here is, again, legislating from the bench, court-made law, wherever, when the court was deciding to conjure up powers and supposed authorities granted to them and their proxies in law enforcement to go ahead and violate the rights openly acknowledged in the U.S. Constitution and then, of course, in the subsequent state constitutions. No, what Jake is saying here is not founded in constitutional reality or in the principles of the founding generation. Reasonable suspicion is not probable cause, which means no warrant of arrest or seizure, searching, whatever, shall issue, because no probable cause under oath or affirmation was made.
fooled by all these exceptions. There are a lot of videos online that have hacks on how to deal with police interactions and things like that. Let me just give you a sound piece of advice. They're all dumb. The best thing that you can do if a
Major demarcations from here. No, if it was dumb to not comply with unlawful orders, to not comply with local law enforcement, or whatever kind of law enforcement, then it was dumb for the founding generation to have done so with the British government. No, it is not dumb. It's not a hack. It is you making absolute certain that the government is continuing to exercise its sole purpose, which is to facilitate the citizens' exercise of their God-given rights, among those rights being the pursuit, or being life, liberty, and the pursuit of property. No, it is not dumb. It is, in fact, one of the most important duties we have as citizens of free governments to make sure our governments, especially the enforcement arm, is doing their job properly. Even if it takes all day, all week, all month, all year, multiple years, they have to be kept in check. One of the most important quotes from the founding generation is, "Resist the first encroachments." Why? Because they will always lead to your last enjoyments. No, Jake, it is not.
police officer stops you, first and foremost, is to not be committing a crime. That's the number one thing. Start there. Now, if you are committing a crime the moment an officer stops you, the next best thing you can do is be calm and obey orders. The absolute worst
Caveat: lawful orders, not all orders.
possible thing that you can be doing if an officer stops you is be committing a crime, not be calm, and not obey orders.
Hi everyone, Donut here. Oh man.
Now, to be clear, if you have a reason to believe that an officer is violating your Fourth Amendment rights, do not argue with the officer during the incident.
Do argue with the officer during the incident. Well, Caleb, that's just dumb. It's a waste of time. Nope. Saying that is directly identical to saying, well, during the Boston Massacre, the founding generation should have just complied with the British. They should have just gone with the courts. They should have just trusted the process. Caleb, look at where that got them. No, do not allow the first encroachments. Do not go quietly. Do not go completely complacent, because the entire process will and is designed to make sure your rights are not acknowledged, are not recognized, and your rights, as quickly and as optimally as possible, will be subverted. No. Argue with the officer. Make sure that because apparently they didn't get a good education as to what the laws and constitutions provide, that they are learned on them. And after the interaction, follow up with a complaint to the department. If the department does nothing, sue them, so on, so forth. No, it is not dumb. It is not a waste of time. It is not a childish hack to make sure your rights go unimpeded.
You're not the ones who are going to solve this problem. Be calm, and after the incident is over,
They actually are, because they're the ones causing the problem.
take the issue before the law. Whether or not an officer has violated your Fourth Amendment rights is not something that's going to be decided by them. It's going to be decided by the court. So there's no reason to fight with them.
That's not remotely true, because they're the ones who believe they can violate your the right acknowledged in Article 4 to the Bill of Rights of the U.S. Constitution. The court's not the one telling the officer to arrest you then and there for whatever reasonable suspicion they may have. It's the officer. Take it up with the officer.
About it, because that's how the law works. The Fifth Amendment is the potpourri of the rights of the accused, and it also throws in the takings clause just for fun right at the end. Here's what it says. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Whew! It's a long one. Anyway, there are 5 things outlined in the Fifth Amendment. Grand jury indictments. Okay, what is a grand jury and what is an indictment? Well, if you're held to answer for a capital or other infamous crime, meaning that you've been accused of a capital crime where the punishment is death, or another infamous crime like a felony, you cannot be tried for that crime unless you are first indicted by a grand jury. This is the only way that the government can bring serious criminal charges against somebody, but remember, it is not the trial itself. Here's how an indictment works. Typically, a group between 16 and 23 people are selected for jury duty. This is why it is known as a grand jury, because it is bigger than the normal jury, which is typically around 12. The local prosecutor, or whoever is attempting to charge the accused of the crime, will then present all the evidence that they have to the grand jury. The job of the grand jury is not to determine guilt or innocence. It is to serve as a check on governmental power, to determine only if the government has enough evidence to establish probable cause that a crime has been committed. The defendant does not present anything during this time because they have not yet been indicted, and you cannot hold them to answer for a capital or otherwise infamous crime without an indictment. So, if at least 12 jurors find that there is probable cause, then they issue what is known as an indictment, and this becomes the official charging document of the case. And if at least 12 do not find probable cause, then the prosecutor cannot pursue the case. Of course, this does not apply to military or JAG law as stated right there in the Fifth Amendment. That's an entirely separate thing that I'm not going to get into right here. Double jeopardy. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. This one's pretty basic, but also essential to liberty. You cannot be tried twice for the same crime after a valid acquittal or conviction. But remember, kids, this refers to each count of a crime, not just have I ever committed a robbery. It's not like you can commit robbery once, go to jail, come back out, and then commit another robbery and not be tried for it. No, we talk about counts. The first one is the first count of robbery. If you do it again, that's a second count of robbery. You can be tried for that. Also, I like the language here. Put in jeopardy of life or limb. You know, like your head. Did you know that France was the last country to use the guillotine in an official public execution, and it happened in 1977? Yeah. Guillotines are humane, okay? I'm just saying. Think about it this way. Blade comes down. Head chops off. Head falls immediately into a basket. Then they immediately roll the body into a casket. And boom, it's a done deal. And guess what? Everyone gets to see why you don't do heinous things to other people. No self-incrimination. Nor shall any person be compelled in any criminal case to be a witness against himself. This is the classic, I plead the fifth phrase.
I plead the fifth. I plead the fifth.
You cannot be forced to testify against yourself in court, and the reason is very simple. It goes back to the idea that if the government is charging you with a crime, they're attempting to take away your life or your liberty, and so therefore the burden of proof is on them. This is where the idea of innocent until proven guilty comes from.
And further, you have zero obligation, according to the Constitution, both the U.S. Constitution, the state constitutions, and natural law. You have zero obligation, despite what the courts want to arbitrarily declare and opine, you have zero obligation to make their job of proving your guilt any easier, to any extent, in any measure, in any form at all whatsoever.
Because remember, by default, you have natural rights and liberties. So if the government is going to take them away from you, they need to prove up their case. As part of this process, they cannot force you to testify against yourself.
1, 2, 3, 4, 5.
Due process. Nor shall any person be deprived of life, liberty, or property without due process of law. Again, due process protects a fundamental right of the accused. The basic idea here is that the government cannot deprive you of some of the most fundamental things you have in life.
This also contradicts what he was saying is supposedly suggested in Article 4 to the Bill of Rights in the U.S. Constitution. If you can't be deprived of life, liberty, or property without due process, then why is it that Jake believes that a police officer can detain you, can arrest you, can impede upon your right to life and liberty without having first fulfilled due process? Those two ideas are contradictory, which is why the first interpretation, the interpretation and court conjurations of Article 4, aren't true. Because if they are true, if those suggestions are true, if reasonable suspicion actually does exist, then that clause in Article 5 to the Bill of Rights doesn't stand. You can either be deprived of life, liberty, and property without due process, or you can't. If you suggest that the fourth and the way Jake was interpreting is true, then that clause in Article 5 is non-binding. Because the suggestion of Article 4 means, yes, you can be deprived of life, liberty, and property without first fulfilling due process.
Without a fair, consistent set of rules. Due process, in the most basic terms, ensures your day in court. It requires a fair hearing, and it also requires an opportunity for you yourself to be heard and to present your side of the story. Ensuring due process ensures that there are consistent, predictable, and repeatable processes even when people are being charged with crimes and they're going through the criminal justice system. And lastly, we have the takings clause, which has nothing to do with the rights of the accused, but they just put it in there because I'm not sure they knew where else to put it. I don't know. Nor shall private property be taken for public use without just compensation. A lot of people don't know this, but yes, the government can take your property from you if it is for public purposes.
No, the government cannot take your property from you. Again, this is something that was just contradicted by the immediately preceding clause. If you can't be deprived of life, liberty, or property without due process, How is it then true that the government can take your property without any process if it's for public use? It doesn't make sense. Why? Because the founding generation, as explained in the U.S. Constitution, and then of course their primary documents like the Federalist Papers, did not grant any government, state or federal, the power of eminent domain. Further, let's play with this idea. Let's suggest, okay, eminent domain was granted to the U.S. government. Just compensation. A person's property cannot be taken without just compensation. How do we determine what is just compensation? Well, what other times do we hear that word just being used? We hear it in the U.S. Declaration of Independence when it talks about the just powers of government. Where do the just powers of government derive from? The consent of the governed. So in terms of just compensation, who would determine what would be just compensation? It would be the governed. Why? Because that's where all just powers of government derive from. So if we want to say that the U.S. government, according to Article 5, that last clause in Article 5 of the Bill of Rights, can in any way take your property, purchase your property, it is only with your consent, only with your permission. Caleb, that's radical, that's extreme, that's outside the scope. Fine. Show me the primary sources which endorse the idea that the founding generation gave the power of eminent domain to any government, state or federal, because eminent domain is entirely contradictory to the sole idea of establishing a free government. No, Jake, the government cannot take your property, whether it's for private purpose or public purpose, unless you give consent. Unless you, the citizen, the owner of that property, give consent. Further, they can't do it. Again, let's toy with this idea in another scenario. They still can't do it without first giving you due course of the law, as was just explained in 2 clauses prior to this one. You cannot be deprived of life, liberty, or property without due process. No, the government cannot take your property without your consent.
This applies to personal property, but most commonly we refer to it in the form of eminent domain and the taking of real property, typically for public works projects. But just because it is here in the Fifth Amendment under the rights of the accused, don't get confused. The government does not need to pay you your just compensation for things that you may have stolen or acquired during the commission of a crime. Those are 2 totally separate things. The government is not going to justly compensate you for all the cars that you stole committing Grand Theft Auto because you thought you were in a Fast and Furious movie.
Pig.
We can quickly explain that because the person you stole from did not consent to you having that property. Hence why what you did is considered theft. So there is no just compensation. There is no compensation in general for that action. There is no property of yours to be stolen because the property is not yours inherently, is not yours naturally. It was the person's property from whom you stole.
Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Okay, let's break it down. The right to a speedy and public trial. Of course, another natural rights aspect to having a crime or a criminal charge brought against you is to have a speedy trial. You can't have a criminal case go on forever arbitrarily against somebody. This is a harm to their name, their reputation, and their welfare. And even if they are acquitted, say 10 years later, if a trial against you goes on for 10 years, and specifically if it goes on for that long and it's not made public, then you don't really have the opportunity to state your case to the rest of the public in your community or your home. Without a speedy and public trial, the government could effectively just ruin people's lives by filing criminal cases against them that just arbitrarily drag on forever and are not made public. And this portion of the Sixth Amendment is to protect against that. You also have the right to a jury in criminal prosecutions, to know the nature and cause of the accusation, and to confront witnesses against you. They must reveal themselves to you, you must know who they are, and they must stand before you and make that accusation against you. This is a fundamental right. Also under the Sixth Amendment, you have the right to compulsory process for obtaining witnesses in your favor. This means that you have a right to subpoena witnesses so you can present your side of the story. What does that mean? Subpoena means under penalty. This means that you can file a subpoena to compel somebody to be a witness for you. This is fundamental because it allows you to present your side of the case and not be reliant on the evidence or witnesses that the prosecution presents. The prosecution could effectively just cherry pick witnesses and evidence, present their side of the case only, and then the jury would only have that information to decide upon. This is absolutely essential to a fair trial, and it's often one of the most overlooked aspects of the Sixth Amendment: assistance of counsel. Lastly, this is the idea that if you cannot afford an attorney for your own defense, legal counsel will be provided for you without.
That is not remotely true. It does not say counsel will be provided for you. It says you have the right to counsel, which means the government, the U.S. government in particular, cannot in any way prohibit you from seeking counsel. Does not mean that the state or the U.S. government is any way then obligated to somehow, using public funds, using resource allocation, provide you counsel, provide you an attorney, provide you a lawyer. No, all that clause means is if you go to seek counsel, any counsel, by the way, notice it doesn't say American Bar Associated certified counsel or counsel certified by any state bar or any counsel approved by the court. No, it says any counsel, that you have the right to confer and have the assistance of counsel. It does not say you are entitled to be provided counsel. It says you have the right to access and confer with counsel. No, Jake, it does not say that the state or U.S. government is in any way obligated to provide for someone having counsel, provide for someone having an attorney or a lawyer. All that means is if you go to seek counsel, if you go to seek assistance, the court can't deny you of that. No government can deny you of that. Specifically, the U.S. government can't deny you of that. It does not mean you are then entitled to representation appointed by the U.S. government.
Charge. We call this type of lawyer a public defendant, and honestly, I have the utmost respect for these people because it is one of the most underappreciated aspects of our legal system. Even if you're a bad dude, even if you're the worst of the worst and you're going to be put to death for what you did, that does not deny you the right of due process and legal punishment for your crimes. Without this fundamental aspect of the Sixth Amendment, we can quickly fall into tyranny, and this is an absolute hallmark of a free society. As a whole, the Fifth and Sixth Amendment rights of the accused are presented to people when they are arrested in the form of Miranda rights. We've all seen it in movies. A police officer arrests somebody and they start saying, "You have the right to remain silent. Anything you say can be used as evidence against you, blah, blah, blah." This is known as Mirandization, and it is actually a legal requirement when you are seizing somebody and placing them under lawful arrest.
This was something else conjured up by the courts. No, there is no constitutional or, well, thereby, if it's not constitutional, it's not a legal requirement. There is no constitutional obligation for anyone to be informed of their rights, whether those be the ones recognized by the U.S. Constitution, their state's constitution, natural law, whatever source. There is no obligation. In fact, there's a long-standing Latin legal maxim which says ignorantia juris non excusat, which means ignorance of the law is not an excuse. It doesn't matter that you didn't know this or that. Your duty, your responsibility as one, a member of mankind, a human, and second as a citizen of any government, subject to any government, it is your duty to inform yourself of your rights. It is nobody else's duty. It is nobody else's obligation to make sure you know exactly what rights you get to exercise. No, the whole Mirandization process was something completely conjured up by the courts.
What possible reason is there for not doing the only thing you have to do when arresting someone?
I did read him his right. I did a version of that.
Eighth Amendment. I'm going to quickly skip to the Eighth Amendment here because it still falls under the rights of the accused, and then we'll go back and we'll talk about the Seventh. The Eighth Amendment says this: excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. I like this one because it's very simple and to the point, but it's also essential. The government's job is to create consistent, predictable laws and to also pair those with consistent, predictable punishments. Punishments cannot be
It's kind of a weird way to state it. The government's sole job, inherently speaking, is to facilitate the citizens' free exercise of their God-given rights. In the context of Western jurisprudence, the way that the government, the U.S. government in particular, goes about doing that is outlined in the U.S. Constitution and then further demonstrated in the superior authority, the state constitutions. Their job, the U.S. government and the state governments, are not to create consistent laws and consistent rulings. It is to make laws and legislate laws that are in pursuance of their state constitutions, first and foremost, and the U.S. Constitution. And from that, laws made in accordance to those documents, to those contracts, then come rulings from courts that apply first the constitutions, the state constitution and the U.S. Constitution, not the law. If the law, or if it's found that the law is compliant with the state and U.S. constitutions, then it can be applied to the case. That's how you get consistency. And I think that's where Jake is kind of leading here, but it seems like he missed that very, 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 very crucial first step. That any law which a ruling is going to be made based upon has to first and foremost be made in compliance with the state constitution and then the U.S. Constitution.
excessive or cruel or unusual, meaning things that are just outside of the norm of what would be expected. Say,
I wanted to mention this, I forgot to mention it. For example, to the contrary, consistency in bad rulings, consistency in upholding laws which are contrary to the constitutions wouldn't be a good thing. Consistency is not the key. It is accordance with the agreed to terms of the contracts. The contracts being the state constitutions of whatever state in which you reside, and then the U.S. Constitution. That's where we get the consistency from, not just consistency in general. So if a court rules consistently with a previous court's ruling, but that previous court's ruling was in contradiction to the state and U.S. Constitution, that consistency would not be a good thing, would not be a virtue, and would not be a key tenet or representative of one of the key tenets of a free state's judiciary and courts.
you commit burglary. Okay, well, one guy goes to jail for 3 to 5 years. First time offense, felony, okay, done. The other guy, we're gonna send him off to a desert island and we're gonna leave him there for 10 years. That would be unusual, certainly, and it's probably cruel unless he's like a Bear Grylls guy, in which case he's just having fun the whole time. Anyway, the Eighth Amendment is nice and simple, and it ensures the consistency across the board. Taken together, the Fourth, Fifth, Sixth, and Eighth Amendments, again, make up the body that we call the rights of the accused. Seventh Amendment. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall otherwise be re-examined in any court of the United States than according to the rules of the common law. The Seventh Amendment protects trial by jury in cases of civil or common law disputes. Now you might say, well, I thought the Bill of Rights was there to protect you from the government, and, well, this is also still true in the Seventh Amendment. It's a little less obvious when you're just looking at the text. You see, civil trials for centuries in England were seen as essential to protecting individual liberty. They would protect against royal judges abusing power, favoritism towards the government, and unfair or arbitrary decisions. And during the ratification of the Bill of Rights, the framers wanted to carry these safeguards into American law. There was concern that the new federal government might centralize judicial power, eliminate juries in federal cases, and allow judges to just generally dominate civil law. Now, the Seventh Amendment still protects you from the government because even though the government's not coming after you trying to charge you with a crime, you might have an issue with them and want to sue them in civil court, or they might try to sue you in civil court. And the Seventh Amendment's right to trial by jury was the Bill of Rights insurance policy to say, hey, even in cases at civil law, the facts and those cases are still going to be decided by a body of ordinary citizens, not government officials. Overall, this helps ensure the legitimacy of the federal court system, which is a mechanism that is just as important to ensuring individual liberties as anything else listed in the Bill of Rights. Okay, the 9th and the 10th Amendments are my personal favorites because they put the final nail in the coffin on this idea of negative rights and negative powers. The 9th states this: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This is saying that just because an inherent fundamental right is enumerated in the Bill of Rights, as in it's written down, does not mean that others don't exist simply because they weren't written down. This list is not exhaustive. It doesn't establish every individual liberty or fundamental natural right that people should have or do have. And so therefore, just be aware, there's going to be things that are going to apply as unenumerated rights that are just as important as the rights we've stated here. Things like the right to privacy, the right to marry and procreate, the right to determine the upbringing and education of your children, the right to travel between the states, and the right to refuse medical treatment are all fundamental unenumerated rights that the courts and the legal system still very much acknowledge as just as important as the ones listed in the Bill of Rights. And the 10th Amendment effectively does this exact same thing, but instead of pointing it at the Bill of Rights, it points it at the Constitution itself. It states this: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Again, this is a reinforcement of the idea of negative powers in the Constitution. It's saying very specifically that anything not written down as an express power in the Constitution and given to the federal government belongs to the states or the people. Did you know that? Did you know that the federal government can only do what it is legally allowed to do as written down in the Constitution? Obviously, in today's context, this amendment gets more and more hilarious or terrifying, depending on how you look at it. In modern printed book format, the Constitution and the Bill of Rights would take up about 12 to 15 pages. Yet last year alone, the federal government printed 3,324 pages of bills that were signed into law. Well, there are obviously a bunch of reasons for this. This simple fact perfectly represents the expansion of federal powers since the time of the Bill of Rights. From banking to social programs, regulations, immigration, and public safety, the federal government is now
Not quite an expansion of federal powers, rather it's just the U.S. government not obeying the terms it agreed to in the U.S. Constitution. So no, it's not an expansion of powers, it's merely just a demonstration that the U.S. Constitution, as almost prophetically predicted by the Anti-Federalists in 1787, would be completely unequipped and ill-suited to restrain this new general government, the chains that it was restrained to in the U.S. Constitution. The Anti-Federalists knew this in 1787, before the U.S. Constitution was even implemented. But no, said the Federalists in the Federalist Papers. It is absurd to suppose that this government would ever not be composed of angelic men, of the most meritorious, of the most deserving men, and they would never step outside the confines of the U.S. Constitution. Well, just as Jake said here, what he finds to be federal expansion of powers, whether he agrees with them or not, it's an untrue term, demonstrates perfectly that the U.S. Constitution was not a good replacement, was not an effective replacement of the Articles of the Confederation. So no, this was, especially the 3,000 pages number that he referenced just a second ago, these are not federal expansions of power, these are instances of treachery, verbatim criminal offenses and violations of the terms of the contract known as the U.S. Constitution that was made between the states and the U.S. government. In fact, I meant to pause when he was going over Article 9 and 10 to the Bill of Rights and explain that those last two articles, if nothing else in the U.S. Constitution, made extremely clear it is not the U.S. government, it is not the U.S. Supreme Court, it is not the U.S. government, or the U.S. Congress, it is not the U.S. executive who is the supreme law of the land. It's not even the U.S. Constitution, as admitted in Article 10 to the Bill of Rights. It is the states. And this is reverberated by, or I guess initially stated, by the father of the U.S. Constitution, James Madison, when he said, ultimately, the powers of the U.S. government are finite, narrow, and directly enumerated. The powers of the states, however, are almost infinite in their breadth. No, this is not a federal expansion of power. It is a dereliction. It is treachery. It is perjury. It is violations of the oaths taken by those U.S. governing officials. They are all violations of the U.S. Constitution. And what Thomas Jefferson and James Madison, Thomas Jefferson, author of the U.S. Declaration of Independence, James Madison, father of the U.S. Constitution, said to be the right reaction to these federal encroachments, not expansions, is to nullify them, is to render them void. That is the appropriate response, not to consider them as federal expansions of power.
Now in more aspects of our daily lives than it has ever been. And it was never intended to be like this. Let me give you a little known fact. Anytime the federal government passes a law, it must point to directly where it derives that authority within the Constitution. It must point to one of its enumerated rights and say, here, right here, this is where we're getting our authority to do this whole bill.
And not an implicit suggestion of a supposed necessary and proper power, but the exact clause, like if you could reference anywhere in Article 1, Section 8, where Congress has any directly enumerated power to do 1/3 of the things that it does, that's where it gets its authority. Not from some implied, well, if you read a little bit further, if you use this dictionary instead of this dictionary, then we can have some sort of iota resembling the power we're exercising. No, it has to be strictly within the confines of those terms. And if it can't be reliably and strictly applied by the confines of those terms, then we have to apply another Latin legal maxim, one of my personal favorites, contra proferentum. We went over this maxim about 6 months ago. Contra proferentum says, whenever there's a question about the terms of a contract, whoever drafted the contract is going to be prejudiced against. It is going to be their duty, their responsibility to illustrate exactly how the terms mean what they're proposing they mean. And if the proposal seems unbased, meritless, then the contractee, the other party to the contract, or parties in this case, are going to be preferred. And they are going to be the party that wins this dispute concerning the definitions and confines of that contract. That's what contra proferentum means. So if there's any confusion, and the founding generation said this repeatedly, if there's any confusion about how to reliably apply the law, about how to reliably apply any clause or provision, it is always, always, always to default back to first the states, in the case of U.S. versus state, and if between state and the people, always on the side of the people. Caleb, that's dangerous, that's extreme. You have to choose dangerous freedom and dangerous liberty over comfortable safety or slavery, or you get neither and you deserve neither. That is the rudimentary principle. Probably not the most foundational, but one of the most important principles of the American Revolution. It is better to let 100 guilty men go free than to convict one innocent man of something he did not do. That's the principle that we have to apply. Dangerous freedom over comfortable safety or slavery. That's exactly why Articles 9 and 10 to the Bill of Rights in the U.S. Constitution were included. It was to make sure that these federal expansions were not viewed as expansions. They were violations, they were treachery. And the only way to effectively deal with treachery and violations, at least according to Thomas Jefferson, was to render the violations null, was to render them moot, and to not enforce them, to not obey them to any extent, to any measure.
We're now signing into law. And this is my personal opinion. This has gone way too far. Now, don't get me wrong. The world has changed a lot since the time of the Constitution and the Bill of Rights, but also
that doesn't matter. There's an amending process in Article 5. If there really are these changing chimes that demand changes to be made to the U.S. Constitution, the founding generation overtly recognized that changes were going to happen, that times are going to change, which is why they said, this document we know isn't perfect. But there is a pretty good and consistent, honest, authentic way to go about changing it without superseding, subjecting, and subjugating all of these different types of people. That's Article 5. And if you don't comply with Article 5, it's not constitutional, it's not law. If you don't like how Article 5 is done, follow Article 5 and have it amended. Point being, you don't get to just say, well, times have changed. That was the past whenever they wrote it. And then start applying whatever arbitrary powers you want to apply. No. Times have changed. You need to amend the terms. You don't just get to say, well, unprecedented times, we have to get unprecedented answers. No, you don't get to do that. It's a violation of the contract. That's treachery. That's perjury. It's a criminal offense.
When you think about it in the context of legal history, with the idea that the Bill of Rights has an 800-year progress going from the Magna Carta all the way up to modern day, it actually hasn't changed all that much in some ways. And allowing this much federal authority is completely outside the bounds of how the Constitution and the Bill of Rights were written. And I think it's about high time we begin trimming that back a little bit. Now, don't get me wrong, that doesn't mean we should get rid of the federal government or something like that, but think about it this way. Most Americans just want to be left alone. You see, Americans are smart. People came here from all over the world to get here. We can figure it out. And that's the basic concept that's facing us when we look at the text of the Bill of Rights. It's facing us directly right there, and it's saying, hey, here you go, figure it out. Government, let them be. Having a federal government solution for every problem that we encounter as a society is not a self-evident net positive for this country. And the reason why that is very simple. It was never designed that way. Anyways, I'll leave you with that. I don't want to take this video too far off track of what its purpose is. And if you've made it this far, I hope you learned something about the Bill of Rights. It truly is a remarkable thing that we have. And I think that it's, like I said in the beginning, every American's responsibility to understand it, because the better you understand it, the better you can determine for yourself what should be allowed in this country. As always, please leave a comment below if you have other video ideas you'd like to see me break down. I hope you enjoyed this, and I hope you're having a wonderful day. I will see you on the next one, and, well, Merry Christmas. It's coming up. See ya.
Well, alrighty, that is the conclusion of Mr. Jake the Lawyer's video. If I had to give him a grade, I would definitely say he did a better job than most of what we would see coming out of American Bar Association accredited law schools. If I had to give him a general grade, I would probably give him maybe a 45 or a 50 out of 100. The reason it's so low is because he did I respected that he didn't interject while reading through each of the articles, but it was key points of vernacular that was really concerning, because they are very importantly different to what's actually stated in the U.S. Constitution. For example, though he started at the very beginning with the appropriate term for Articles 1 through 10 of the Bill of Rights, throughout the remainder, he called them amendments, Amendments 1 through 10. That right there is worth about 10 points of deduction for me, because the Bill of Rights were not negotiable. They were not changes after the U.S. Constitution was adopted. They were prerequisites. They were required for individuals like Thomas Jefferson to even consider supporting the U.S. Constitution and its ratification. Very important difference. Another point, significant point of contention that dropped me about 10 to 15 points of grading for him and his performance was his continual reference to the U.S. or to the United States, these United States, as being a country, as being a nation, Americans. All of these different important terms. James Madison, again, father of the U.S. Constitution, made very clear in the Federalist Papers that they were not forming a nation, they were not forming a country, they were not forming a state. He said, even though at some points, in some ways, it seems like we're doing that, it seems like these are national powers, ultimately, it is a federal union of equal, independent, sovereign states. It is not a country. These United States are not a country, which is why it is still called the United States with a S, plural, and not the United State, no S, singular. It's also why the states were told, well, not told, retained their individual governments, kept their constitutions, kept their legislatures, kept their executives, kept their judiciaries. Point being, calling these United States of America a country is akin to calling the United Nations a country, a nation. You can't, a union, which is what the U.S. government is formed upon, as described in the preamble to the U.S. Constitution, a union cannot be a country. A country is a solitary unit. A union is a collection of solitary units, which leads directly into my next point. In fact, I think I'll change it from 15 to 20 points of deduction. You cannot be a citizen of a union. You cannot be a citizen of a collective. You can be a citizen of a singular unit like a state or a country or a nation, and that state can be a member of that union, but you cannot be a citizen of a collection. You're a citizen of your state, and your state is a member of the union. Caleb, that's extreme. That's so far outside the scope. It's always important to remember Thomas Jefferson, James Madison, George Washington all died as Virginians and frequently referred to Virginia as their country, not their state, their country. They died as Virginians, not as Americans. That is such an important, it seems trivial, it seems petty, but it is such a significant aspect that if we remind ourselves of, we can actually start getting back the true form of government that the founding generation intended to create and formed in the U.S. Constitution. But until then, kind of like what Jake was alluding to there at the end, that all of these solutions that we hope come from the federal government, not necessarily being a net positive, that's true. The U.S. government, as detailed by James Madison, has very limited, narrow, and directly enumerated powers, while the states virtually have infinite powers. So first problem, he called Articles 1 through 10 of the Bill of Rights in the U.S. Constitution amendments. He called these United States of America a country, a nation. Further, his explanation and all of the exceptions that he allowed, which do not exist in Article 1 to the Bill of Rights in the U.S. Constitution, were without foundation, or without merit. There are no exceptions listed in Article 1. Which is funny because just earlier in the same video, he said, hey, did you know that the U.S. government can only do what it's provided in the U.S. Constitution? But then he goes and starts applying all of these different exceptions, all of these different limitations that actually aren't listed in any of those articles in the Bill of Rights of the U.S. Constitution. His understanding of Article 4 was better than most, but not on point with what was going on. Same thing with Article 5 and his belief that eminent domain was carried on over from the English sort of jurisprudence, the British jurisprudence. It was not. The founding generation did not at all believe that eminent domain was a legitimate power of government, which is why they included the just compensation edition of that clause. And who determines what is just? The governed, the consent of the governed. And this applied also when he was going about explaining, I think it was the 7th article, Article 7, or Article 8. I can't remember. I know I interjected while he was giving his explanation. Lastly, really those are the only demarcations. The last one, I demerited, 5 or so points for his explanation on Articles 9 and 10, because he didn't really go to the length and the breadth that those two articles were purposefully included. They were purposefully included, and this is explained, if I remember correctly, almost directly by Thomas Jefferson. Those were included to make absolute certain, the states were not, and it was to be understood, that the states were not consolidating into one country, into one nation, into one state. This government was formed for the benefit of the states. And that whenever this government, the U.S. government, becomes contrary or acts contrary to that purpose, the states have every single right to alter, abolish, reform, or leave the U.S. government in any manner that they saw fit to then restore, of course, those foundational principles, to establish, form a government which would then fulfill that sole purpose of true, just, and honest government. So in total, I would definitely say that Mr. Jake the lawyer better informed, better learned than the vast majority of ABA attorneys, ABA indoctrinated attorneys, still nowhere near the standard of, what do you want to call it, acumen necessary in order to uphold, in order to maintain, in order to even apply what are the principles, the understandings, and the doctrines of a free government. So in total, I would give him a grade of 50, 45 to 50%. So, Mr. Jake the Lawyer, if you see this lecture, I hope all of these explanations help. If you would like primary sources, I have plenty to provide that substantiate and corroborate all of the positions that I'm echoing from the founding generation. So please, don't be embarrassed. Don't hesitate to ask. I can very quickly provide those primary sources for you. All right, let's go ahead and wrap it up because I see we're already way past the hour mark. I apologize for that. If you have any questions about what I said in this lecture, if you think I'm totally off my rocker, or maybe there's a legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions, including you, Mr. Jake the Lawyer, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.